On behalf of all my colleagues at the law school, faculty, staff, and students, let me welcome you to the CIP2 2023 Annual Fall Conference. We're glad you're with us. Great group of attendees. Nice that we can be in person, and everyone in person, although we will be recording this. Each year, this gathering brings together leaders from industry, government, and the academy to discuss cutting-edge IP issues such as first sale and their impact on innovation. CIP2 is an important part of the Scalia Law School. We have 7 academic centers. This is one of the great centers that we have at the school, and we appreciate the leadership of Joshua Kresh and of his predecessor, but still very much involved, Professor Seán O'Connor. I myself am an entrepreneur, and I love entrepreneurial stories, and I think that the Scalia Law School itself is a great story of innovation and entrepreneurialism. The school is less than 50 years old, so we're competing with schools that have been around for 150 years old, 150 years in the Commonwealth of Virginia. It started as a true startup, as an independent law school in a brownstone walk-up in Washington, D.C., with a different name and even different mission. It was called the International Law School, and the goal was to have an inclusive education, but one that was focused on an interdisciplinary approach to education. You know how conservative the ABA and the accreditors are, and nobody wanted to accredit that law school. So the law school, even though it had great faculty, many who were adjuncts, great student body, I think many or most who were, night students, school was about to go out of business. So what does an entrepreneur do when that happens? We pivoted. And it got acquired, so I guess you could say it had a type of liquidity event or an exit, and was acquired by George Mason University, moved from downtown DC to right next door into actually a department store that they renovated. We're now in the building next door, Hazel Hall. But I think it's a great story. I guess you could say we were rebranded or recapitalized when we got $100 million worth of funding and the school was renamed in 2017. We're proud of the fact, and sorry, I'll refer to U.S. News rankings, that we're now ranked as the #2 school in the Commonwealth of Virginia, behind only UVA and ahead of a lot of schools that started before us. If you compare us to the schools in D.C., again, we're #2 behind only Georgetown. And if you look at the 17 law schools in D.C., Virginia, and Maryland, we're now #3. So I think it's a great story of success, and we're proud of it. I want to thank everyone again for being with us. The panelists are superb. The moderators will, I know, do a great job. You bring great expertise and experience. You bring a lot of diversity and viewpoint, which is really important to this law school. So thank you for being with us, and I'm going to turn it over to Joshua.
Thanks very much, Dean Randall. So good afternoon and welcome everyone to the Center for Intellectual Property by Innovation Policy, CIP2's annual fall conference, First Sale, the Role of IP Rights in Markets. It's wonderful to see all of you today for this exciting event. I'm honored to serve as the Interim Executive Director of CIP2 here at George Mason University Law School, and I want to extend our warmest welcome to all of you. We have attendees joining from around the world, lawyers, academics, business leaders, policymakers, students, and more. Your presence here shows your commitment to engaging in thoughtful dialogue around critical issues related to intellectual property law and policy. I want to start by taking a moment to thank our advisory board members for their guidance and support of the center, and to many of them who will be speaking and or moderating over the next few days. I also want to give my sincere thanks to our sustaining donors, the Association of American Publishers, AbbVie, Bio, the Copyright Alliance, the Walt Disney Company, Ericsson, the Motion Picture Association, NBC Universal, Nokia, Novartis, Pharma, Relics, the Recording Industry Association of America, and VIA Licensing Alliance. Additionally, we're thrilled to have dedicated conference sponsors: Gold, VIA LA, Silver, Harfang IP and Kirkland & Ellis, LLP, Value Support, LexisNexis, IPlytics, Millen, White, Zolano and Brannigan, PC, SAG-AFTRA, and Save the American Inventor. We're thankful for their generous financial support. We want to open our public event to as many people as possible and could not do so without their support of our sponsors. We're not funded by the law school, so we rely on donors and sponsors to run all of our programs. Over the next 2 days, we have an incredible lineup of panels and speakers exploring IP issues arising from major Supreme Court decisions, new licensing approaches, national security issues, and tech innovation, the metaverse, crypto, NFTs, and generative AI. Impacted doctrines include first sale, SEPs and FRAN, TRIPS waiver, functional claiming, so-called patent thickets, and more. This year, we have concurrent sessions for the first time, which allows us to have a few more panels than usual, although it means you will have to choose. Don't worry if you want to see both, as we are recording all the panels and we will share everything after the conference. Also, please fill out the anonymous surveys available at the registration tables to let us know what you think about the conference, and in particular if you think the multi-tracking makes sense this year. I hope you all take advantage of this opportunity to engage with experts in the field, build new connections, and take part in meaningful policy debates. The intimate setting we've created here is designed to foster fruitful exchanges between stakeholders across different perspectives. Further, after today's closing panel, from 5:45 to 7, we're looking forward to a special reception honoring Judge Pauline Newman of the Federal Circuit. Co-hosted with the GMU Intellectual Property Law Society, we hear more about the judge from speakers at the reception and from the judge herself. But I'll start by saying I don't think we could fully cover her impact on patent law if we spent the next 2 days on it. The reception will also include Scalia Law students and IP alum, and we look forward to giving an update on the Scalia Law IP program at the reception. We also appreciate our student volunteers, research assistants, and past research assistants who will be in attendance. And I want to point out a change for tomorrow's schedule. Panel 6A, which is one of the concurrent panels set for after lunch, will be starting at 1 o'clock to accommodate one of our speakers. We'll make announcements tomorrow before the lunch and during the lunch when it's time to head to the session. 6B will remain on its scheduled time. Thank you for being part of our community. I wish you a wonderful couple of days immersed in thought-provoking dialogue. It's now my pleasure to invite Professor Seán O'Connor, my predecessor and now faculty advisor to CIP Squared, to kick off the conference with a discussion of the origins of patent exhaustion and first sale. Seán, whenever you're ready.
All right, hello, everyone. I'm going to do that thing where I try to talk and do something with the computer at the same time, which is usually wildly unsuccessful, but there we go, I did it. All right, hope everyone is excited for a day and a half or so of programming. As Joshua said, this is the first year we're doing concurrent programs. A lot of you go to Fordham and other, conferences. You know that it's done. Is there somebody running the sound? Because it's really running the edge of feedback. Christina, do you know if anyone's in control of this? Okay, yeah. Hey. So I think the concurrent sessions are going to be quite good because they allow us to cover more ground, and you get a lot more content coming in. All right, now, as you may have seen from the program itself, there is a theme. We always have a theme to our conferences. This one is on first sale or exhaustion, depending if you're on the copyright or the patent side, depending which you like to call it. So I'm going to kick off the conference by telling you that exhaustion doesn't really exist. Controversy right out of the gate. But in fact, so I did this research a number of years ago, and then unfortunately, wildly unfortunately, I was not able to get it to the point where I could publish the article before the impression products decision happened. I think who knows, Supreme Court might have ignored me anyway, but at least, Counsel for Lexmark, was interested, and had it been done a little sooner. The origins of exhaustion are pretty murky. And all the commentators and patent profs who've looked into it, when you go down the rabbit hole, you're like, wait, in those original cases, Bloomer v. McEwen, where's the transfer of the goods, right? Because the whole thing, right, we all know, for exhaustion and first sale, it's that you have a physical object. It changes hands. That physical object was covered by some IP rights, whether it's copyright or patent. And then that physical object, once it passes out of the hands of the patent owner, it's free. It's free. Patents don't cover it anymore. The patent rights are exhausted. The fascinating thing when you go down the rabbit hole of those 1800s cases where this doctrine emerged from is that they did not have any transfer of physical goods. It was a franchise. Okay, so that's what I'm going to do. I only have about 20 minutes to do this, to sum up what's a very sort of convoluted paper otherwise, but to show you the origins and not just give you a kind of historical exercise in which you might say, well, who cares, because we have the doctrine, and on the copyright side, it's codified in the statute anyway, so it's a done deal. It is the law of the land, but my argument is that conditional sales should still be possible, even after impression products. And in particular, though, you would have to do it through conditions subsequent, which I'll explain through the course of this presentation. Okay, now, let me get into slideshow mode. There we go. Now, I'm talking about this because this is a room full of people who know what I'm talking about, right? Although, I don't know, you're usually when I have my class, I was teaching contracts this morning, and I'm like, nod vigorously. Because, I have some of my students in the room, they know that I do that to them. Because otherwise, I don't know. Am I saying this? Does any of this make sense? Is it something you don't care about or you don't understand what I'm saying? I'm assuming in this room, right, we all know the basics of exhaustion and first sale, and we also know the cases, the Kurtzang case on the copyright side and the impression products case, right? And so I am mentioning here, so I'm going to give an overview of the talk. I'm going to argue it's not so impeccable of a pedigree, right? That's what Breyer said in Kurtzang. It's impeccable pedigree of this exhaustion doctrine. And then Roberts picks up on that quote in Impression Products. I'm going to tell you instead it's a legal fiction created by, for a political purpose, Jacksonian Democrats, Chief Justice Taney and Justice Clifford, and they had an agenda. What was the agenda? It was to limit federal power as against states' rights. You see that in their other decisions. So this patent stuff, we get this doctrine out of it, sort of just another way for them to run a certain agenda that they had. Whether that was a good or a bad agenda, you can decide for yourself. But this is sort of almost like collateral damage of their agenda, okay? So the canonical case, the seminal case, Bloomer v. McEwen, which everyone traces exhaustion doctrine to, okay? And exhaustion on the patent side comes first. We later start thinking about copyright first sale historically after it's appeared on the patent side, okay? But so Bloomer v. McEwen, there is no sale or transfer of physical goods. So it cannot be an exhaustion case. It's not. Okay, so I'll tell a little more about that. Also, you see a lot in the cases, the modern Supreme Court cases, about, well, this is because of this old common law rule against restraints on the alienation of chattels, okay? That's really important. And then they go back and they cite what looks like really important authority. Lord Cook. Looks like Coke, but I've heard it's pronounced Cook. And Cook is citing Littleton, an even earlier treatise in Anglo jurisprudence. And so there it right says, and I'll show you the quote in a few moments, this great old, almost sounds like Shakespeare language, right? This old English, and it's talking about, sounds like exhaustion. Sounds like we don't want restraints on alienation. What do we mean? Well, if I sell you a good, you should be able to retransfer to do whatever you want with it. Okay, well, if that's the old time immemorial common law rule, then patent exhaustion is just the necessary next step of that. However, it's a little weird because, in fact, Cook and Littleton, and then Gray, who gets cited a lot in the modern Supreme Court cases, he's writing in the late 1800s, they have these huge treatises on what? If it was a simple rule, you wouldn't have a treatise. You would just have, here's the rule. You can't restrain the alienation of the physical goods once you sell them. Why do they take, Chipman Gray takes 500 pages or something to say it. Why? Because there's a bunch of permissible restrictions. So it's not a simple and fast rule. In fact, there are plenty of ways you can restrict what a purchaser can do with something when they buy it. So a lot of this has all just been taken really quite out of context, okay? Before impression products, Supreme Court hadn't categorically ruled that patent exhaustion applied to all sales, no matter what form they took. And a lot of you remember the Mallinckrodt decision under the Federal Circuit, very much allowing a kind of conditioned sales. So we have impression products. It tries to solidify what it says is this very simple, clear-cut rule. And so, again, in the remaining time I have, I'm going to problematize that for you and argue that there's still a pathway forward for a kind of conditional sale. You don't have to just retreat to, well, we'll license it. We'll lease or license the physical object, or we'll provide it as a service. Okay. And the real hook to how you would still do, arguably, conditional sales is by going back to that great contracts, remember your contracts classes, conditions precedent versus conditions subsequent, okay? And then jump over to property class, reversion rights. Remember that thing? You buy property, if it's not fee simple, you have a life estate in something, and then it can revert back after a certain time? Same thing can happen in personal property. So that could be used then to show that it's not a fee simple transfer. Okay, so now let's get right into it. Okay, and people remember what I say about this in the cases talking about the impeccable pedigree. Yes? Again, nod vigorously. If no? Not somebody? Okay. Just nervous here. I don't want to, I don't want to talk about something no one really cares about. Lord Coke did not lay down a general prohibition against restraints on alienation. What were they doing? Littleton and Coke were concerned with abuses of restraints in real estate. And what were they really thinking? It's tough when you get to my age, a lot of you are my age, and your cultural references, they were later on cultural references. You think you're still cool, but then even your later in life cultural references are dead now. So Downton Abbey, does anybody watch that back in the day? Now it's back in the day, it still seems so fresh. What's the animating thing? There's an animating legal issue in Downton Abbey. Remember, first season? That's all. Yeah, some crazy old English property thing, and that brings Matthew involved because somehow, and what's her name, Mary, she can't actually get Downton Abbey unless he's involved. So I don't know. I'm not a property expert. I just know just enough to be dangerous with this topic here. Okay, so why am I saying this? Well, because there was a lot of kind of dead hand restraints that people like Littleton and Cook did want to wash out. They didn't want it to be that property ended up kind of in a dead-end situation where it wasn't clear who could control it. That's all they were trying to do and say, look, we don't want excessive restraints on alienation, okay? And then, ultimately, what Littleton and then Cook and then Gray are talking about is a simple tautological principle. If you understand the concept of a fee simple transfer, meaning it's all rights, title, and interest, there's no strings attached, then of course you as the seller can't say, oh, but by the way, surprise, gotcha, you have to give me back the property, you can only use it in certain ways. Right? That would just go against the definition of a fee simple transfer. But in fact, there were ways that people were trying to do that through these kind of clever restrictive covenants. And so that's all that this one cherry-picked section out of these, multi-hundred-page treatises that Breyer picks out first and then Roberts amplifies. They're taking way out of context the one kind of exception, the one just really tautological. Oh, and by the way, if you tell someone you're giving them all rights, title, and interest to this object, you can't then spring it on them later that they don't, in fact, have all rights, title, and interest. If, on the other hand, you do some form of conditioned sale and the buyer is on notice that they're only getting some of the rights, title, and interest for some period of time or it's divided otherwise, that's completely permissible, okay? Okay, so what is it? Anyone, you've probably seen this, especially in, it's mainly in Kurtzank. So here's the language, probably impossibly small. If a man be possessed of a horse or of any other chattel, and give or sell his whole interest therein upon condition that the donee or vendee shall not alienate the same, the condition is void, because his whole interest is out of him, so as he hath no possibility of a reverter. And it is against trade and traffic and bargaining and contracting between man and man, is within the reason of our author that it should oust him of all power given him. Have you seen that quote? Breyer loves this quote. It sounds good. It sounds like, right, that's it. You can't have this crazy, conditional sale thing. All right, but now read it in the context of what I just said. And secondly, it's a marginalia gloss. The thing that's being cited by Breyer and then picked up by Roberts is Cook commenting on Littleton's treatise. So if you look at the original, here it's almost like, it's like, and he was done almost like, I actually took, whatchamacallit? I took Jewish law, Talmudic law. I took Talmudic law in law school, and it actually came in handy for all this. And you see a lot of even medieval scholars in Europe doing the same thing where here is the original, whether it's a scripture or some other canonical text, and then you put your comments, which can be often printed on the sides. That's what it is. So Cook's like this, we're putting all this weight on this thing. It's literally in the margins. It's just Cook speculating. He doesn't cite any cases for this. Whereas in Littleton's treatise and in Cook's own other writing, he would give some sort of case common law authority. It's not. He's just kind of like, well, I kind of think, because he's riffing off of a thing about if it's a fee simple transfer of real property, he puts in the margin, yeah, this kind of makes sense. And look what he says. The condition is void because his whole interest is out of him. I transferred you, I told you I was giving all rights, title, and interest. I give or sold you my whole interest. I can't trick you later on. It's quite straightforward. Okay? There's no possibility of a reverter because I didn't condition it on a reverter. Okay? So I hope you see that this is very shaky ground now suddenly to put this whole doctrine on, that somehow there's a rule against alienation of property. Okay, now, and as I said, then these treatises, John Chipman Gray's, go on to quite a bit of stuff about all the ways in which, think again about life estates, in which you can have conditioned transfers. Now, let's shift over to what was happening in the mid-1800s. Okay, so, patent farming. It's a term, I think I made it up. Either I stole it from somebody. It's like tax farming in the old Roman era. But basically, patent farming is, I am going to try to monetize my patent by assigning or licensing it out to people regionally so that they can then go ahead and try to make money off it and then pay money up the chain to me, right? Systems like this still go on today. What was important to understand is that going into the mid-1800s, while articles of manufacture, simple things like metal irons and things, were being produced and kind of relatively mass-produced and distributed, more complicated machines were not routinely being manufactured in one place and then distributed across the country. Instead, what was happening was the person who held the patent on the machine would license it to local people to build their own machines and operate them. Okay, so that's what was going on here. And so it was an accepted practice. Eli Whitney with the cotton gin tried to do something similar. Okay? So it was a franchising system. It relied on the local licensee to either themselves or find the local blacksmith or whoever could make this thing for them, to manufacture it locally for them. And so there was never a time where the patentee or the patentee's own controlled manufacturing entity made a physical object and then distributed it to somewhere else. Now, what was really critical in this system was then for the patentee obviously wants to maximize their revenues, but it also is a pretty good deal for the local franchisee. And now think about, if any of you, maybe some of you have dabbled in it yourself, try to, I'm going to be an entrepreneur, I'm going to get a franchise of like, Starbucks or McDonald's or whatever it is. What's your core interest if you're going to pay a lot of money for like a Starbucks location? You want to know that there's not a Starbucks right across the street, right? Now, I'm also thinking about Instagram. It's really funny. There's a lot of stuff about Dunkin' Donuts. It's really become meme-ified in New England, I mean, you have Dunkin' Donuts down here, too. And the hilarious thing is people posting on IG, like, the classic thing. It's in, like, I think it's in North Station in Boston. And it's like the sign says, oh, this location closed. Use the location on the other side of the hall for Dunkin' Donuts. Like, literally, in the same waiting room, there's a Dunkin' Donuts on each side. Now, that's not ideal, it would seem, because you're really cannibalizing, the two people across the way. So that's all really that Woodward, who owns this patent, that's the centerpiece, it's what the Bloomer v. McEwen litigation is all about. What it is this system under Woodward and all of his assignees. He had regional assignees. All right, you get the Northeast, you get the Southeast assignee, and I'm giving you assignee. Okay, you don't have all the rights entirely, but you have enough title that you can further sublicense and you can bring enforcement actions in your own name. Okay, so critical, we still do that today. But the critical thing was masterminding this so that in each town there was only one or two of these these wood planing machines, so that the ultimate licensee, who is paying good money for this franchise, could make money. They didn't want the market to be saturated. Okay, so that's what's going on. Distinguish it from some of you might have heard about patent sharks in the 1800s, and even today there's sometimes overblown stuff about patent trolls. Now, it is true that there were some operatives in the 1800s, especially under the pre-1836 registration-only system, where you just registered the patent and then enforced it in court. There were some people who were bad actors who took out patents that really should not have been issued and really were overstating what the claims had. But hold that aside, that kind of patent shark or patent trolling activity, from these more proactive, we want to get this technology out. Again, we can't manufacture and distribute machines, so we're going to have to then license local people to build them, okay? Now, another complication is that when this Bloomer v. McEwen case comes up, the 1836 Act has come about, and there's a proviso in it to try to cover when these earlier pre-1836 patents, there's a change in the law now. Can they retain rights? Are the rights good against assignees going into an extra term, essentially? I'm not going to, it's a real rabbit hole of like trying to understand this Section 18. And that was the problem. So the other issue is that Taney in Bloomer v. McEwen, and it's actually it's a bunch of merged cases. It's not just one case. In those cases, Taney and the other justices were trying to figure out how to interpret this statutory proviso. So it's not even remotely a case about common law or common law rights or about patent law generally. It's just a situation where some people felt like these patent rights were springing back open after a term had ended. And then this was going to be a very limited window of a problem, because once all the pre-1836 patents were expired, all the patents going forward wouldn't have this issue anyway. So it is a little odd that we built up an entire universe of exhaustion doctrine out of something that was a stopgap statutory interpretation problem. Okay? That's why, so what often happens when people look into the roots of, and I finally decided to go down the rabbit hole for real, other people looked like, I don't know, this is very confusing, no physical objects change hands, we can't figure out what was going on. So I spent a lot of time, and if you want, I have a whole paper and you can look at all the gory details in it. Taney uses this, though, to springboard, as he did in other cases, think about other famous or infamous Taney decisions, to try to kind of make up law that goes far beyond what he needed to do for the holding. So what's Taney trying to achieve? Well, in the Jacksonian Democrat movement that he's very much part of, he wants to bolster states' rights, local rights, as against the growing power of the federal government. Okay? So he seizes on this case to say, oh, wait, this is hardworking local craftsmen who have built their own machines and are using them, so it's just under kind of personal property rights, that should be state law, and now somehow these kind of evil remote patentees who own these rights are preventing them from continuing to use these machines that they built themselves. Okay? So then he comes up with, in what's essentially dicta, that's the other problem. This quote is quite arguably just dicta in the case. It doesn't resolve the case at all. Because again, there's no objects changing hand, but he has this great quote that people love, and this becomes the heart of exhaustion to the current day on the patent side. And when the machine passes to the hands of the purchaser, it is no longer within the limits of the monopoly. It passes outside of it and is no longer under the protection of the Act of Congress, the Patent Act. It sounds like something happened. It sounds like physical object changed hands. He knows there wasn't, because he decided one of the lower appellate decisions, and he writes very clearly. He knows what this franchise situation is. So it's a little bit of a gloss. It's a little bit of a clever kind of thing. Now, in truth, when you read the whole context of it, you could, if you wanted to be charitable to him, say, well, what do you mean by not, I didn't mean literally the machine passed to the hands, I mean the rights to the machine have passed to the hands of the purchaser. Purchaser, not of the machine, but of the patent rights, of the franchise rights. However, Taney does build off this, again, dicta in the Bloomer v. McEwen case, to then make it sound like it does apply to actual transfers of goods, and then his kind of acolyte then, Clifford, picks up on it even after Taney dies and goes a lot further with it, and that's how we really get built into the case law then, this exhaustion idea, although Clifford moderates it some after the Civil War, okay? But by that point, it still has taken on a life of its own. I'm not going to recount, because then most of you who have looked at this at all will know the Adams v. Burke and the cases that pick up in the late 1800s. But this is the part that's always confusing to people, and they just often leapfrog over this. We don't know what happened in Bloomer v. McEwen, but somehow we get this exhaustion thing, and then we have all these other cases. Okay, now, one other part that takes up what might have faded as a doctrine. Exhaustion might have faded away, but for the late 1800s, focus on antitrust, anti-monopoly, okay? And so another set of justices picks up on this, what was then called emancipation, not exhaustion. And they say, oh, wait, this is interesting. This is another way that we have monopolies, unfair monopolies, by then people having these patent rights that then they can try to extend around the country and restrict what people are doing. So they go on and do their own glosses. Okay, so now let me bring this to a bit of a close, and I'm happy to take questions on any of this. Given all this, some of you will know the early 1900s and mid-1900s cases that a lot of it turned on notice, right? So, well, wait a minute, you can have some restrictions on post-sale use if you clearly had a notice that the buyer got and understood they could only do so much. That was the Mallinckrodt thing, all the way as late as Mallinckrodt. You knew it was a single use, there was health reasons for it being single use, arguably, so you knew what you were getting. If you didn't get the notice, then the notice was ineffective. So that part is going on. But what never gets clearly ruled about is express notice, the buyer fully understanding that they're getting a conditional sale, that they don't have all the rights. It's not fee simple, okay? Now, what's important about conditions precedent and conditions subsequent? Well, in precedent, there's something like John Duffy covered this in an article he wrote with a colleague, I think Richard Hines. And it was around the issue of exhaustion, but talking about that basically in the 1800s, when you're looking at this, if you were buying something on financing, then you wouldn't get full title to the object until you made all your payments. And that makes sense. So full title doesn't pass until then. So that would be condition precedent. But, okay, so that's fine. So, and even I think the Supreme Court today would be like, yeah, look, if title hasn't fully passed, then it can still be conditioned until it fully passes. But once it fully passes, now you can't. But now let's bring back conditions subsequent. Okay, think about it, again, the easiest one, if you remember from like 1L property class, it's that life estate. Okay, I sell somebody a life estate in Blackacre, and then at the end of the life estate, it reverts back to me, or maybe I've had it set up, goes to someone else, and maybe I put restrictions because I don't want you to waste or do other things with Blackacre while you have it. So you have some restrictions. So yes, it's a sale, but it's a condition sale, and it may have a condition subsequent. You do something, you lose title. You have title, but then you can lose it. Okay. So that's the odd thing that Roberts doesn't really deal with. And instead, what Roberts does is, you remember, and I remember when this came out, and people loved his, remember the Remora comment? He's like, well, it can't be. If we have these weird restrictions, post-sale restrictions on articles of manufacture, machines in the stream of commerce, they'll be sticking Remora-like, that the fish that sticks to the side of a shark, right? It's a great image. I give him huge credit for, it's a great line. It's a memorable line. But he knows better, right? He was a business lawyer. There's all kinds of things that go along. There are a lot of things that stick Remora-like to a transfer of something. You can very much have conditioned transfers of property rights, and not just real property, but personal property. So it's kind of odd that he does that in the patent context when it wouldn't happen otherwise. Okay, so the real issue then that you have is, let's say my system works, okay? So let's say you want to sell, let's say Lexmark decides to actually try to take up on this and make another go of it. And then they, in their recycle program, say, you buy this, you have full title to the cartridge, unless you do something else. If you do that other thing, title to the cartridge as personal property reverts back to us, okay? That's doable, and wouldn't that'd be enforceable under property law, right? Title reverts back to us. So the only question from my argument then would be, can the patent rights reopen at that point? Right? Because under exhaustion, the sense is, as long as the other person has full rights, title, and interest, then you can't restrict what they do with that physical object. But if the physical object comes back to my possession, why don't my patent rights cover it again? All right, well, I'm basically at the end of my time. I'm happy to take any questions on this, although you might be like, that was odd. I don't know what to make of that. But I'm going to try to run with this. I'm going to try to keep going, get people's attention, and try to, I really need somebody to actually just go for it and test it and do a test case and do this kind of condition subsequent sale, and then we'll litigate it up and see what happens. All right, what do you think? Is this going to work? Does this idea work? Show of hands. Okay, I got some of you. All right, any questions? Yes.
Is this guy Taney the same guy who wrote Dred Scott?
Yes, and that's how I was, yes, exactly. That's the problem. And I've heard it's Tawny. Like, I always said Taney too, but I think it's Adam Mossov was on the faculty, you all know, he assured me that it's Tawny. Anybody else know? I think it's Tawny. Yeah. Oh, right, Chris, you know too. So he wrote, and this is, if you look at the Bloom v. McEwen opinion, it's really much of a piece where he just goes way off on dicta to make a bunch of stuff that sounds law-like, but had nothing to do with actually resolving the case. Other questions? Okay, well, if not, we're at the end of time. I want to keep us on schedule, so I'm going to turn it back to Joshua Kresh.